of Illinois being summoned to federal court to answer a complaint filed by the U.S. Department of Justice over a state law that the state passed to have worker privacy. But the DOJ saying that it's obscuring their ability to enforce federal immigration law when it comes to employment verification. It's Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell, and wake up with us each and every weekday morning as we break things down for what's going on in the capital city here in Illinois. But sometimes we have to look at what Washington, D.C. is doing and how Illinois is reacting, as we've got litigation that's been filed against the state of Illinois on a couple of different fronts, especially when it comes to the non-citizen migrant status of sanctuary status for Chicago, Cook County, and the state of Illinois. But now we've got a lawsuit that was filed late last week from the U.S. Department of Justice dealing with E-Verify. And this, a lot of you employers out there know about this. You have to, get an I-9, and then have, people attest that they're citizens and such, and then they provide their social security number, and then all of a sudden you can start getting paychecks. Well, let's go through this. The filing here, it really will help elucidate what the arguments that the U.S. Department of Justice is bringing up. So in the U.S. District Court's Northern District of Illinois, you've got this case. Plaintiffs, the United States of Illinois, by and through its undersigned counsel, brings this civil action for declaratory and injunctive relief and alleges as follows. This action, the United States seeks a declaration invalidating and preliminarily and permanently enjoining the enforcement of certain provisions of Illinois law. The provisions are preempted by federal law and therefore violate the Supremacy Clause of the United States Constitution. A primary motivation for illegal immigration is work opportunity. To curtail this, Congress enacted the Immigration Reform Act 1986. A section of the Immigration and Nationality Act requires all employers to verify the identity of employment authorization of their employees. ICRA created the E-Verify program, among other things, provide employers the ability to confirm that their employees are legally authorized to work in the United States. Using E-Verify, an employer can electronically compare information the employer enters from an employee's Form I-9 employment eligibility verification to records already available to the Social Security Administration and the U.S. Department of Homeland Security. This verification electronically reviews an employee's eligibility to work in the United States, but will also notify the employer of a tentative non-confirmation called a mismatch and prompt for further action by the employee to confirm employment eligibility. By maximizing employer participation in the E-Verify program, the United States is able to reduce economic opportunities for authorized aliens seeking to work in the United States unlawfully. Additionally, because E-Verify's effectiveness depends on employer participation, any limitations on new enrollment into the E-Verify program necessarily impedes the federal government's ability to evaluate E-Verify's utility and effectively enforces INA's employment eligibility verifications. A lot of words there, right? But that just gives you kind of a gist of what the U.S. Department of Justice is laying out as to what the federal law is, why the federal law is there, why E-Verify is important, why employers have to work with the E-Verify system and interact with it, what kinds of things they get back to find out if the individual applying for a job or who was hired for a job is actually eligible to work in the United States. So those are the types of things that we're talking about here. But let's go back to the lawsuit, the complaint that the federal government has filed against the state of Illinois. It says in August 2024, Illinois enacted amendments to the Right to Privacy in the Workplace Act, SB 508 amendments. They regulate Illinois employers' use of employment eligibility verification systems. They impose restrictions on use of those systems and provide civil and criminal sanctions for violation of SB 508. These amendments, which took effect January 1st of this year, are preempted and should be enjoined because they violate the Supremacy Clause of the United States in at least three ways. First, certain provisions of SB 508 are expressly preempted by federal law, which disallows any state or locality from imposing civil or criminal sanctions on employers of unauthorized aliens. Second, the challenged provisions of SB 508 are field preempted because They provide additional regulation in the field of administrative process governing, Form I-9 documentation and inspection. E-Verify, even though Congress has occupied the field. Third, the challenge provision of the SB 508 are conflicts preempted by IRCA because the bill stands as an obstacle to the accomplishment and execution of the full purpose and objectives of Congress to root out unauthorized employment and to encourage employers' voluntary participation in E-Verify. So again, you go through and it's 20 plus pages of this, and the Department of Justice saying up front they're looking for permanent injunction against the states and to essentially find this law as null and void in the federal courts. And an injunction essentially says, hey, you're found to be in the wrong, state of Illinois. That's just the latest there. Of course, as I said, the state's been summoned to respond to this, and where exactly this is going to go, it's going to be fascinating because you've got the ongoing lawsuit about the sanctuary status in the state of Illinois and in Cook County. So that case proceeds. They've filed things. Last week we talked about that with even Cook County Board President Tony Prewinkle visiting Springfield. I was able to ask her questions about where she's at on this lawsuit. Chicago Mayor Brandon Johnson as well, with the sanctuary status of Chicago being sued by the federal government. And then you get this new case that the federal government brought late last week, suing the state of Illinois over its so-called Workplace Privacy Act, saying that it's obscuring the ability for federal immigration authorities to ensure that people are eligible to work in the United States, and also levels penalties against employers. The federal government says goes against federal law when it comes to this particular issue of interacting with E-Verify. So a status hearing is set for that E-Verify case that the DOJ has brought against the state of Illinois, and that's set for July 2nd. So that's coming up pretty quick here. The state obviously is going to have to respond to the allegations, the civil complaints that the federal DOJ has brought against the state of Illinois. So that's the latest there. But just to revisit again, because we've got the latest, obviously, in the challenge against Illinois' sanctuary status, Cook County's sanctuary status, and Chicago's welcoming city status. Just to hear again what Chicago Mayor Brandon Johnson and Cook County Board President Tony Prewinkle had to say when I asked them about the DOJ's assertion that allowing for non-citizens to not be detained by ICE, even if they're in a local jail, has caused some public safety concerns across the state. Here's Board President Tony Prewinkle talking about how they're going to defend their policies in Cook County.
I think President Trump and his allies have decided that the way in which they're going to manage the federal government is to overwhelm and demoralize those who might be in opposition to what they're trying to do. And one of the challenges for us in this shotgun approach to executive orders is their focus on immigration and challenging sanctuary and welcoming cities, counties, and states. So we're being sued by the federal government, as you said.
Is there any wiggle room here to address the concerns they have? I mean, the DOJ said that one example was a Cook County detainee, an illegal alien, was released without ICE being involved, and then 17 days later is arrested for homicide.
I'm not familiar with this particular case, and we're going to fight the federal government's efforts to allege that we are not compliant with immigration law. I mean, my view is that immigration enforcement is the obligation of the federal government. Let them do their job.
And that seems to be the position that the state's taking as well. We'll look at what the state had to say recently in their filing, but to that DOJ assertion that a illegal alien was in Cook County jail, ICE was kept from trying to get that individual as they were being released, and then that individual was released and 17 days later was arrested, suspected of murder, of homicide. So, again, I asked Chicago Mayor Brandon Johnson that question last week.
The DOJ says that an illegal alien was released from Cook County Jail without ICE being able to intervene. and then 17 days later was arrested suspected of murder. How are the welcoming city policies not harming public safety?
Well, first of all, public safety is the top priority for me, like I would imagine all mayors around the state of Illinois. And violent crime continues to go down in the city of Chicago. I'm not sure if you've been able to track those numbers, but since I've been in office, there's been a precipitous decline in violence, and we're going to continue to do all that is necessary to create a safer Chicago for all. We do need Congress to actually hold the executive branch in check. We can't normalize what this president is doing. He has eroded the Constitution, and that's why there's significant lawsuits all over the country that are pushing back against the unconstitutional nature of his iniquitous form of governance.
So the mayor there saying that he's bringing down crime and that the state's sanctuary status is not harming public safety. But then when you work in, concerns about the Safety Act, because sometimes you can get a little lost in all of these different, laws and names, right? The Safety Act, that was what regulated police a whole bunch, brought about some criminal justice reforms like no cash bail with the Pretrial Fairness Act, right? So that's the Safety Act. That deals with whether or not people are going to wait in jail before they actually go to trial for allegations that police level against them and state's attorneys level against them. So that's the Safety Act. Then you get to the Trust Act and the Way Forward Act. Those are the sanctuary state laws, right? Enacted, the Trust Act, by Governor Bruce Rauner, a Republican. The Way Forward Act went further under Governor Pritzker, and essentially it says that state and local law enforcement can't communicate with ICE. They can't ask individuals their immigration status. I should pull up texts I get from some of the law enforcement community as to the issues they're running into, and feel free. I mean, law enforcement, listen, if you have my numbers out there, all right, you can go to bishoponair.com and find it. It's not necessarily an invitation to everybody to do this, but if you've got anecdotes, it helps me better understand the types of things you're dealing with, because I mean, I've got story after story people are sharing with me anecdotally about how they can't even ask the immigration status of somebody they pull over, but they know for a fact that the individual is not from the United States and likely in the country illegally, and they can't do anything about that other than to write a warning that they were speeding or something. So yeah, those types of things it makes law enforcement frustrated, especially when they find out that an individual is then released from jail and then they go off and commit other crimes. But let's take a look at what the state has to say here. In their response to the DOJ looking to find the state's sanctuary state policies null and void. This is just the table of contents from the state's most recent briefing, essentially pushing back against the DOJ. All right, so the state says the preemption challenge to the Trust Act fails. They say that no federal statute compels state and local police to facilitate or effectuate civil immigration detentions. The 10th Amendment preserves Illinois' ability to opt out of federal immigration enforcement, and plaintiffs' attempts to disregard it fail. Federal supremacy over immigration policies does not authorize conscription of state officers as immigration agents. Neither Murphy nor the extradition clause justify invalidating Illinois' sovereign choice to opt out of civil immigration enforcement. No part of the Trust Act, they say, is expressly preempted by federal law. Illinois' decision not to participate in civil immigration enforcement does not regulate or discriminate against the federal government, and the governor is not a proper defendant. We've already gone through some of those issues that the state's brought up in this particular case, but clearly the case is going to continue, right? They've got a motion to dismiss in front of them that the state, Cook County, and city have put out. You've got a motion for a permanent injunction that the DOJ has put out. So now the judge is going to have to weigh all of this. Which motion is the judge going to address? The motion to dismiss? Or are we just going to go right to, making sure that we have an actual process of hearing the merits of this and kicking it up to the appeals court and possibly up to the Supreme Court? This is going to take a long time to get through this particular case. But again, the case we talked about at the beginning, the E-Verify case, that case is just starting. So we'll do what we can to keep you guys posted on all of this. All right. It is Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell. Wake up with us each and every weekday morning with the Center Square on YouTube. Get the podcast where you get podcasts. And also, don't forget to get the newsletter in your inbox. Just search Illinois in Focus. Wait, no, that's for the podcast. Go to the Center Square to get the newsletter. All right, it's Monday, people.